Good morning, friends. Today I will talk about what is contempt of court. The contempt of court was known to the public recently when the Supreme Court of India has held former vaccine promoters guilty of contempt for violating its order. Now, the expression contempt of court has not been defined anywhere in the Constitution, but still, as per Contempt of Court Act 1971, contempt is the offense of showing disrespect to the dignity or showing disrespect to the authority of the court. Now, we can divide this contempt into two eras. First one is civil contempt, and second one is criminal contempt. If we talk about civil contempt, it is willful disobedience to any judgment, decree, direction, order, writ, or other processes of the court, or willful breach of an undertaking given to the court. Now, coming to the criminal side, criminal contempt, publication which may result in scandalizing the court by lowering its authority, interference in the due course of judicial proceeding, or any obstruction in the administration of justice. Still, if there is any innocent publication and distribution of some matter, fair and reasonable criticism of the judicial acts and comments on the administrative side of the judiciary do not amount to contempt of court. Further, going by the Contempt of Court Act 1971, this act defines the power of the courts to punish for their contempt and regulate their procedure. Its amendment was done in 2006, and as per section 13, implying that the court must permit justification by truth as a valid defense if it is satisfied that it is in the public interest. Now, coming to punishment for contempt of court, both the Supreme Court and High Courts have the power to punish for contempt of court, either with simple imprisonment for a term up to 6 months or with fine up to 2000 or with both. In 1991, the Honorable Supreme Court has ruled that it has the power to punish for contempt not only of itself, but also of high courts, subordinate courts, and tribunals functioning in the entire country. High courts too have been given special powers to punish contempt of subordinate courts as per section 10 of the Contempt of Court Act 1971. Now the question is, why it is the need for contempt law? The purpose of contempt jurisdiction is to uphold the majesty and dignity of the judiciary. Contempt powers help judges to do their duties of deciding cases without fear, favor, affection, or ill will. Now, going by the constitutional provisions, if we go by Article 1 to 9, it grants Supreme Court the power to punish for contempt of itself. And Article 142, subclause 2, enables the Supreme Court to investigate and punish any person for its contempt. If we go by Article 215, it grants every High Court the power to punish for contempt of itself. Now, on one side, Article 19, subclause 1A, it gives the right to freedom of speech and expression to all citizens, while contempt provisions curb people's freedom to speak against the code's functioning. Moreover, this Contempt of Court Act of 1971 is subjective in nature, which may be used by the judiciary arbitrarily to suppress their criticism by the public. These two are the drawbacks. Otherwise, it is the need of today that contempt of law should be implemented to save the judiciary from unnecessary criticism. This is all about contempt of court act, and I hope you might have enjoyed this very well.